Great. Hi, ladies and gentlemen. Do sit down, make yourselves comfortable. We should start this afternoon's session. Okay, wow, it's very bright up here. Everybody comfy? Everybody paying attention? All good? Are we all sitting down at the back there?
Well, I was at the
lovely. All right.
On Friday.
Ladies and gentlemen, welcome to our discussion about solving the privacy Rubik's Cube. The comparison with the Rubik's Cube is one that Brad Smith made this morning in a blog post a while ago. In the wake of the safe harbor suspension, we need to learn how to do 4 things together and simultaneously. 4 things which at first glance might look like they're actually in conflict. We need to protect privacy as a fundamental human right. We need to keep the public safe. We need a global internet, but then we need a legal path which works well on both sides of the Atlantic. So it is a bit like a Rubik's Cube, or I thought of a more Brussels analogy, which is it's like the predation of Boulevard Ansbach, where you fix one thing and then a load of other ones break and there's total chaos. So how can we avoid that happening in the online world? We've got a great selection of experts here to discuss burning issues, including safe harbor, Mutual Legal Assistance Treaties, or MLATs, one of the many acronyms we can enjoy this afternoon, the new EU data protection rules, and major court cases on both sides of the Atlantic. Jan Techau earlier promised that madness would ensue when we got to the panels. I'm sure these guys will do their best. You've got lots of information, both on the screens and in the various things you've been sent about who we've got. So instead of using the limited time to make big introductions, I'll actually get the panelists to do that themselves when we have our opening remarks, because I know there's been a lot to take in, and of course, we get to the reception after this. So I'm very keen that we should finish in good time so you can enjoy that. Let's start by hearing from John Frank, who is Vice President for EU Government Affairs at Microsoft. Tell us about your part of the puzzle.
Thanks. I'm just moving to Brussels, and so I will be leading our EU Government Affairs team here. But for the past several years, I've been based in our corporate headquarters in Redmond. Not only have I spent the majority of my career at Microsoft in the office next to Brad, but we've spent the majority, really long collaboration on this set of issues. And so I've had the law enforcement national security portfolio for the last 5 or 6 years at Microsoft. And so for the Snowden affair, I was on point for that. For the Irish email warrant case, that was my team. I planned that, bringing that forward. And so we've been collaborating as a team, trying to figure out what the right solutions can be. The Irish warrant case, it doesn't solve a problem, but it does point to a major problem. It points that we need to figure out a solution that respects privacy, security, and national sovereignty. And we're very sympathetic to all 3 of those values being central, and that so we're having lots of dialogues with Department of Justice and other governments about how do you manage those in a world where the security aspects really are important. We do live in a dangerous world, and I don't think there's any more important function for a government, or no greater responsibility, than keeping its people secure. And so we understand that security is really a paramount importance to governments, and yet we want to find solutions that respect the need for security while also respecting sovereignty and privacy.
Perfect. Very nice. So good set of what you're doing there. You mentioned the DOJ and the US government in general. So next, let's hear from Michael Olmsted, who is Senior Counsel for EU and International Law Enforcement Matters at the US Mission to the EU.
I work for the Department of Justice in the United States. I am stationed here in Brussels because we believe that it is valuable to try to enhance the policy discussions within the EU institutions with some of the values that we carry on the law enforcement and to some degree the national security side. I would say that our interests at the interest of my particular office is more focused on law enforcement. I've been doing this for 30 years. One of the things I want to point out is that when Brad Smith says that we lag behind the innovation of the internet, the answer is absolutely. We always lag behind the innovation of the internet. That's what makes the internet innovative. If they were to wait until we had a set of policy rules in place before they figured out that we really ought to be able to send an email from one person to another, or you ought to be able to attach a PDF document to an email, or that you might want to have a suite of programs that talked to each other so that when you had a good idea, you could share it instantly. If they waited for the policymakers, either at the EU or the United States, to come up with a way that ought to happen before it happens, you wouldn't have it. And so the idea that we are playing catch-up is not something that should be seen as a weakness. It just is a fact. One of the facts is that on September 10th of 2001, I used to be a director at Interpol. I wasn't then, but I have been since. On September 10 of 2001, if you wanted to speak to Interpol, you wrote them a letter that arrived through the French mail. You could not email them because there was no email. They didn't have those computers. There was no, this is 2001, you could not fax them because they wouldn't accept faxes. They weren't formal enough. And you couldn't call them on the phone because that's also too casual. That was 14 years ago. And that was, Interpol, just for people who don't know, is a communications network among 191 member states whose police forces communicate. It is Facebook, so to speak. I know that's heresy here. It is, it is the equivalent of Facebook for police, which is that they all communicate to each other and post notices on each other's, whatever they're called on Facebook. So, on their home pages or whatever. All of this has changed in the last 14 years, all of it, and we have laws that are trying to catch up. I usually, if I have a PowerPoint presentation, it only has 3 slides. The first slide is a picture of the world at night with all the lights. That is the electrical grid of the world. That is the internet. That is what criminals get to see. And then I have another slide of the world with all of the geographic borders. And that's what governments see. They see the divisions that come from national sovereignty. And the question is, how do you lay one of those on top of the other and have a coherent ability to protect the citizens that choose our government? One of the things that I would like to point out, I mean, and I've said this in other panels, Microsoft, you know, we are in the midst of a fairly lengthy piece of litigation, but the fact is, they're trying to obey the law. They're just trying to figure out which law to obey and how it applies. We are trying to enforce the law because we have a commitment to the people who sent us there. But if anybody thinks that any of our governments feels anything but a line that comes from our Declaration of Independence, that our governments derive their just powers from the consent of the governed, if you don't, that is what we are there trying to accomplish, which is, what does the public require? When Oklahoma City blew up, with Tim McVeigh, no one was asking where Microsoft was. They were asking where the Justice Department was. And so we have a constituency that requires us to be serious, to be responsive, and to try to keep up with the smart guy in the room, unlike the lawyers, the smart guy in the room who figured out how to build the internet. And so I hope today we get to talk a little bit on our steps to try to come to a coherent, respectful way of obeying law while imposing the natural limitations that come with national sovereignty on top of a grid that has no sense of that sovereignty. Thanks.
Perfect. Thank you so much. So it's very interesting. Talk about the lawyers. Next is hear from a lawyer. So let's give the floor to Isabelle Vereecken, who is Privacy and Data Protection Legal Advisor at the Belgian Data Protection Authority.
Thank you. Yes, to give my background, last years I've been involved in the negotiation of the GDPR, but I'm also in charge of international transfers at my DPA. I worked for the Working Party 29 to develop new tools for transfers, such as new contract clauses, new BCR, processor, controller, and also negotiation with APEC economies. So I just would like to underline that I have more business context approach than a background on law enforcement or on national security. So the invalidation of the safe harbor creates lots of legal insecurity for the business. And you all know probably about the statement of the Working Party who give like a grace period for which for the political to find a solution, legal and political solution. My intention here is to try to propose you to consider this problem and this moment not as a problem, but as an opportunity to find solutions, an opportunity to find a right balance between security, fundamental right, and economic interest. There is a need to find legal solution that enables to pursue the legitimate national security interest and law enforcement interest, but without undermining fundamental right and trade. Business like Microsoft has understood since years that the data protection could be seen also as an opportunity and not only as a compliance duty, and an opportunity to develop trust with their consumers. And I think that also it is the case for any democratic state that needs the trust of their citizens and from their counterparts too. There has been too much legal insecurity because the citizen trust and data protection has not been taken into consideration from the beginning. And so a lot of time and money has been wasted. I'm talking about the invalidation of the safe harbor, but also the invalidation of the direct data retention directive, on which many member states took legislations. Telecom operator need to retain data. They have to discuss which data, who's paying for that retention, and then everything has been invalidated by the court. So I will make a link with the GDPR that requires now new duties for data controller, like to make PIA, privacy impact assessments, and to try when processing implies high risk for rights and liberties. And GDPR also requires to build systems taking data privacy into the design. And so it is important to integrate privacy for the building of any legislation that will help to enhance trust. So the challenge is not only addressing the transatlantic transfers between US and the EU, but also member states. As you probably see also last week, there has been a ruling of ECHR against Hungary on their national security legislation. So my idea was to try to propose here to have a more positive attitude and to try to take into consideration of data privacy in a positive way to avoid any future problem in front of the court for the next solutions.
Brilliant. Isabelle, that's fantastic. Thank you so much, because it's good, there's another part of the Rubik's Cube is it's not just a flux between the EU and the US, there's also all kinds of things going on here in Europe as well. So everyone's going to make these laws, then comes the actual hard part of enforcing them. Olivier Burgersdijk is Head of Strategy at the European Cybercrime Centre of Europol. So tell us about your work.
Thank you very much for this introduction. Also, my thanks to the organizers for having me here and giving me the opportunity to shine light on this from the side of law enforcement. I'm a Dutch national. I've worked for Dutch law enforcement for many years before I joined Europol. That was in 2006. And in 2006, basically I started in the area of information management, information processing, information exchange. So I saw throughout the years quite a number of challenges when it comes to information management and in particular data protection. Europol has a very interesting legal framework, very well organized, and basically it says to us, you are there to support the member states in their efforts to fight and prevent various forms of crimes. When it comes to the cooperation with the private sector, and that of course is in the area of cybercrime, a very important partner when it comes to getting relevant information, it says you can get information through national authorities. So no, not directly, but through national authority. That of course is something that we built in and around our system, and in 2013, when the European Cybercrime Center was established, we established actually a specific team that deals with all the external relations to deal as efficiently and effectively with our partners in the private sector and academia. I must say that works really, really well. There's quite a number of partners that have a very positive atmosphere, approach and willingness to cooperate with us and to make sure that jointly we make the internet safe. There's of course also a number of limitations, and a good example of that is the fact that businesses are organized in function of their objective, and that is to make money for their stakeholders. That means that they are as efficient as possible in dealing within Europe. For instance, they may have 1, 2, or 3 representations within the EU, and from there they do their business. But the internet makes it possible for them to, from there, run a European service. And it might be that they accept a credit card from Lithuania from someone who buys something to be delivered in Estonia or in Spain or wherever. This company might be based in Ireland or Belgium. And if they then have to report a crime with that in Belgium or in Ireland, that local police force has no interest in the case. So that is one of the challenges that we are faced with on a regular basis. And of course, we then try to come up with solutions by bringing them together also at the level of law enforcement to make sure we have the common priorities in dealing with these cases. Thank you.
Perfect. Thank you so much. Great. So lots to think about there. I guess, John, if we come back to you, you're a company, you're there to make money. How do you fit into the Rubik's Cube? Because one of these themes is, the shifting of responsibility gradually onto private companies.
Well, I think we see ourselves, obviously, we have commercial interest, but also in the mix, we do try to think about our customers. But we're also, we value citizenship everywhere we do business. And we want to be able to engage with a set of, the set of dialogues with different interests so that we can, in a sense, where exactly the solution comes out isn't so important as that we help contribute to a solution being found. Whether it's on, law enforcement, there's a crime that they're investigating and the data's in another country, we come up with some criteria that we think our customers want, and we try to engage customers and civil society and government, and you can think of just sort of game theory of if you get the right people at the table, the interest will be discussed and people understand more and help find a solution. And I think that's generally, I don't know how many, I guess there's 6 sides to Rubik's Cube, and there's multiple interests involved, and we would like to advance that. And sometimes we'll take steps that are a little more aggressive to try to be a catalyst to get change, because while the law is always going to be lagging behind, sometimes that for societal progress we need to push it forward.
Perfect. And with, so you mentioned customers. I think one of the things that's interesting is how much are people responsible themselves. So Commissioner Jourova said, as soon as we make this thing law, we're going to educate people, we're going to make them know their rights. So I don't know who wants to come in on this, but how much is it up to people to take their own responsibility for security online? Is that a...
That's really the best.
Yeah, go on.
Well, I think that if we look at the problems that we have in terms of cybersecurity, there's 2 elements. One is from the side of the criminals, where it's very easy to buy malware packages, etc., and to commit crimes. Why? Because the vulnerabilities in software that are known, that have been remediated are not used by the victims. The victims don't update their software. They don't update. They often don't have any antivirus protection, and the result is that it's very easy to have a huge attack surface, and that is something where the individual citizen, but also companies, can better protect themselves.
Perfect. So I hope you're all very responsive about when you get that Windows update warning that you will say yes straight away. It's an important message. Isabelle, you're a DPA.
Yes, I think that I don't know if it works. Yes?
Yeah.
Okay. Now it works. I think that for asking users to take their own responsibility, what is important also is to be fully transparent to them, to enable them to really understand which solution they have to take and which option they are. And I think that up to now it's not so easy. I mean, when you make use of internet tools or you are downloading an app, for instance, you just have, I'm talking now with a business interaction. I think that it's quite complex to read all the legal information and to see the options. And I think that it's quite interesting to see, for instance, how in the GDPR they developed the idea of having some icons to enable user to make good decisions. But in some other aspects, such as how the state is making use of the data, what is important to enable citizens to take their own responsibility is to give them right to do that, and to give legal redress, for instance, to enable them to go in front of justice and to have clarity on how the data is used, and if they can challenge and have more information on that.
Yeah, no, and that was a very strong message from Eurova earlier of like, come on guys, hurry up and sort out the Judicial Redress Act. Michael, are you confident that will be done soon? Or
They have scheduled a Senate write-up Thursday,
okay.
and anyone who can guess what the Senate's going to do is not sitting on this panel.
But I have a question, if I may.
Of course.
I take the opportunity, but on this legal redress bill, does it apply for the disclosure of information between a company to an agency, or does it only apply on exchange between two agencies?
The Judicial Redress Bill doesn't apply to either of those. The Redress Bill tries to allow it tries to allow the citizens of designated countries to have the same rights that American citizens enjoy under what's called our Privacy Act. And so the Privacy Act gives American citizens, and it specifies that it's Americans, so that's the issue. The Privacy Act gives certain rights to American citizens to obtain information, to correct information, and that is held by the government. And that right is not offered to anyone other than U.S. citizens. The Judicial Redress Act says that citizens of designated countries, and those countries will be designated pursuant to a certain process, that citizens of those countries will enjoy the same rights under the Privacy Act that U.S. citizens have to information that is covered by the Umbrella Agreement. Now, the Umbrella Agreement is what you're asking about, which is the Umbrella Agreement, or the DPPA, is an agreement that has been initialed but not yet signed between the parties, between the EU and the United States, which regulates the manner in which, or provides protection that corresponds to the 28 mutual legal assistance treaties, plus all of the other agreements we have to transfer information, that if there is a transfer of information from a law enforcement authority to a law enforcement authority, the protections of the Umbrella Agreement will persist with that information once it goes from the United States to Italy, or from Italy to the United States, or any of the EU countries. The Judicial Redress Act is politically linked to the Umbrella Agreement, but it's not technically a part of the Umbrella Agreement. The Umbrella Agreement could go forward without it. We are told politically it will not go forward without it, and we're working on that assumption.
Great. Let me broaden this question out, because
Can I just jump back to some of the cybersecurity points? And we've worked with Interpol, we've worked with the Department of Justice, and the governments around the world on taking down botnets. That, I think we've done about 15 or 16 now, where it's a very sophisticated distribution of malware that once you get on your machine, it shuts down your antivirus, and it in some examples, for example, it'll take screenshots of when you go to do your online banking, and without your knowledge, it'll be sending those screenshots back. And so, we've worked with governments in terms of, exercising the police authority to take that down, and then we redirect when your computer is infected, it has sort of a phone home mechanism as part of the botnet. It's always checking back for the latest instruction set or the latest update, and as frequently as 4 times an hour that you're online. And so we redirect that back to our sinkhole, and then we can identify the IP addresses of infected computers, and then we share that with the national certs so they can work locally to help get those machines cleaned up. But I think I wonder if we're being ambitious enough with our cybersecurity policy and not doing more to actually kind of treat it as a public health issue, or getting people to, when you drive on the road, you can't drive an unsafe car. And there is an externality to an infected computer because it's being used for all sorts of other purposes, including sending junk mail and denial of service attacks and things. And so whether it's the internet service provider or others, I'm just curious, have you thought about more ambitious things than simply information sharing to actually create mechanisms to get people's computers cleaned up?
Olivier.
Well, it is the problem is we're not in a position to impose things on users. We are there to identify who the criminals are, to try to arrest them and to have them convicted. I fully agree that in this partnership that we have with CERTS, with a number of companies like Microsoft, some antivirus companies as well, in this partnership there is this ambition as well to include the part of the remediation, but usually it gets very little attention. I fully agree, and that is something that we should do more with. But the possibility to impose limitations on a user is something which is certainly not for us, but it's definitely something that should be considered. I fully agree. I mean, as a user of a computer, if you are aware that your computer has been affected and is actually being used for committing crimes, why can that go on? What is the logic behind that? I mean, in your car, you would immediately be stopped if you know that something is not working and it hasn't passed a test that you used again. You're not allowed to. And for computers, apparently, it doesn't matter. No, I fully agree.
Olivier, could you even go further? I mean, could they be more proactive in the way that they work with you? Is there anything you'd like to see?
I think there's a certain cautiousness in companies in the way they operate. For us, what we want is, if a crime has been committed, we want to be able to investigate that and get the information for that. Now, whether a crime has been committed for a company that has customers that are abusing their services, there is a certain cautiousness in whether or not to report that. Because here there is a balancing of the rights of these customers versus that of other customers. And obviously it should be very clear that there should be the moral obligation to report this and to end the abuse of these services to commit crimes to other citizens or businesses. But quite often the army of lawyers in these major companies is bigger than the number of people we have to investigate these crimes. So there's, for them, a certain cautiousness before they come forward. And also there's I mean, I fully agree with the opening statements today of these are the best of times, these are the worst of times, and especially also with the Snowden revelations, there is also for companies a cautiousness in where they position themselves.
Great. We might get some in-house lawyers to ask some questions later. Maybe Michael, you want to come in?
There's one thing I can tell you that I think companies really could do a lot better, and they could explain to law enforcement how their businesses work when law enforcement comes to them. Microsoft participated along with Apple, I guess, with a seminar that we put on at jointly with the Eurojust, and a lot of what got discussed is how do you set up your system? You have to remember that the police don't know how you have decided to employ the internet. How have you decided to break up transactional data from subscriber information from content? Is there a subset of transactional data that is very different in your context, which isn't differentiated under the existing statutes? Those are the kind of things we don't know anything about. I mean, I can tell you on the financial world, in the last panel, someone was saying that the internet, we should think of kind of an analogous set of problems that come up in the financial world. I recall in my own life subpoenaing American Express Bank for some materials. They are a correspondent bank. They called me up and said, do you know you've just asked for like 5 million records, none of which is going to be responsive to what you really want. So they sent me a 200-page book about how correspondent banking works. I read it again. I came back, asked for just a little bit of information, got what I wanted, and moved the case forward. That companies could do that a lot with law enforcement. It would be really helpful because what happens sometimes is police or prosecutors go and ask for information. They ask for something that isn't actually useful. Companies then fight it because it takes forever to answer those questions or else they provide the information without saying the only piece of information you actually care about is on the second paragraph of page 7. That would help a lot. It would help the companies because they wouldn't have to deal with us very much, and it would help us. Anyway.
Perfect. You're a company.
I was going to say, one of the, it's easy to assume that we all have perfect knowledge of how our companies work. And, one of the really interesting things about getting to be a lawyer at Microsoft is there's an art form to interacting with the engineering teams. Because you learn that if you ask the question this way, engineers are very precise. They'll answer the question precisely as you asked. Now, trying to broaden it out and get, it takes a certain diplomacy with them, but also a certain precision and persistence to kind of get the broader set of information. So I hear you that it is useful for us to, create. We don't want to be compromising our customers' privacy and security, but we're very happy to engage to explain about how our systems.
Yeah, in fact, I think that ends up protecting a lot of your customer security because I'm not asking for the 53 people that I've unintentionally asked for. We can narrow it down to the one person that might be the subject of an investigation or something like that. So I think it actually is useful from a privacy perspective as well.
Perfect. While we're on the subject of law enforcement and what companies can do, in the wake of the Paris attacks, a lot of there was a call from the UK government in a way for backdoors for law enforcement, and then it was Julie Brill at the FTC who said it's magical thinking that only the good guys can use this magic backdoor and the bad guys can't. Is that something any of you would like to come in on?
Well, look, it's a tough issue, and I think that. Going back to my earlier point, some precision questioning would make it easier. I think when you just put up this giant question of encryption, is it good or bad, or should there be backdoors for encryption? It's such a big question that it's scary. People get scared about lots of different things, but there should not be backdoors because you don't know who else can use it. We're open to other solutions, but encryption is extraordinarily important to protecting the privacy and security of governments, of individuals, and enterprises. And we all have, we want to be able to communicate securely, and so it is, it's fundamental. And until we get a better solution, just asking the broad question, are you pro or against encryption, I think it's one of those problems that leads to more friction than light.
Brilliant. Olivier, are you pro or against encryption?
Well, it's a very difficult question. And if you look at some practical cases where we've seen that the only thing standing between us and protecting lots of abused children was one person who didn't want to give his password, that is difficult. The question is whether you can do it in a different way. How can you circumvent this? And what we then do with arrests is that we try to arrest people at the moment that their computer is switched on, so you don't need the password to get into that. Another alternative, and so far the interception of telephone calls, for instance, was done at the central level by the telecom provider. And under very strict rules, there's a possibility for us, if we have a good reason to suspect that crimes have been committed, that we get the authority to get intercepted communication for a specific purpose with all kinds of conditions on that. Now, with encryption, that interception becomes more difficult to decipher. And as an alternative, you can look at either backdoors, but it's just one avenue. You can also look at how can you get beyond the point of encryption or decryption, meaning on the device of the criminal. And if you have a good reason to believe that crimes have been committed, you know which device is being used by the criminal, why couldn't you get a court order saying, yes, you get the authority to hack into that cell phone and to make sure that that communication can be used. As long as there's a legal basis and a limitation of the use of that for specific purposes, that can also serve as an alternative.
Fantastic. Great. All very interesting stuff. Now, one of the reasons we're having this discussion is because Safe Harbor has been suspended. So now what comes next is a big part of the Rubik's Cube. Isabelle, I can't resist asking, and I know you're limited in what you can say because the Article 29 Working Party plenary is in just a couple of weeks, but is there anything you can share with us in terms of what you think a post-Safe Harbor world will look like?
So, the thing is that so it's true that in 2 weeks, in fact, the Working Party 9 will take a position, an official position. So for me, it's quite important to not reveal information in advance because this decision in practice has not been taken yet. But what I can tell you, what we are doing right now is to try to yes, analyze the impact of the Schrems decision on the other transfer mechanism, and because as the court says that the national surveillance law was overriding the safe harbor principles, we see how it would also affect the other transfer mechanism, because probably it will be the case also for BCR or contractual clauses, and so. The problem is that the Working Party and the DPA is not in a position. It's not a solution maker because he cannot reconcile such difference of hierarchy of law and contract. But what DPA task is to enforce the law and to regulate and to protect fundamental rights of citizens. And it is why the Working Party 29 called. The member states and EU institutions, but it will be also the responsibility of US, of course, to try to find a political and legal solution for that. The best would be, of course, to have some results in this negotiation. If it wouldn't be the case, I think that the DPA will be just in a position to enforce legislation and to try to protect the right of citizens, and so the idea is also to make an analysis of the U.S. national, foreign legislation law, in order to assess how it will meet the EU standards.
Perfect. Michael, where do you see this intersection of lawful access and safe harbor?
Well, I think all I can say is that a lot of people are working very hard to make sure there isn't a post-safe harbor world. That we are trying to make sure that there is a new safe harbor world, and they are meeting every week, talking almost every day, trying to make sure that they come up with a framework that will both provide privacy and allow business to operate. So I know that they are working on, I was in Paris on Friday on this. I know that they are working very hard. And because there are so many moving parts, and because we don't negotiate in public, I'm not going to go further than that, but we are working very hard to try to make sure, and I'm sure Commissioner Jourova says the same thing, which is that they would like to establish a framework that survives ECJ scrutiny and also allows business to go forward.
Okay, perfect. John, why don't you tell us what you think, and then we'll open up the floor for questions.
Sure. When I first joined Microsoft 21 years ago at our European headquarters in Paris, my first project was preparing for the launch of our online service, the Microsoft Network, which eventually became MSN. And it was my first confrontation with, we had to get privacy. You know, it's like, well, as an American, I showed up, but what is this privacy thing? And spent many, many hours with the CNIL, just helping them understand what it was about. But I think, you know, as a company, we've given a lot of thought over the years to privacy. And Brad's a great advocate at the most senior level of our company, but it is a value that we've come to embrace with a great deal of passion and enthusiasm. And so we want the safe harbor to get worked out. We probably would be more flexible than some of the governments on some of the points. We're not party to it, but we think it's just incredibly important that it get worked out. Not to be the skunk at the garden party, but there is one point which I think could be a significant problem, which is in our lawsuit at the Second Circuit Court of Appeals right now. If the court were to adopt the position that the government prosecutor put forward to the court, which basically said that the U.S. privacy statute, the Stored Communications Act, only applies for when a service provider discloses data in the United States. And they took the position that that's why the statute's not extraterritorial. And they accept the corollary, very logical, but I'm not sure very wise, that Microsoft or Google or Facebook, we could deliver data delivered from Europeans or Americans outside the U.S., and that wouldn't be a violation of the statute. And so generally we view the Stored Communications Act as a very important privacy shield, but there's now this gaping hole in it for data that could be delivered outside, and we get demands all the time from governments around the world who don't always share the most democratic principles, demanding data about customers. And up till now, we've been able to say, no, U.S. law doesn't permit that. And if this argument is incorporated in the Court of Appeals decision, I think that's going to be a significant additional problem that will make U.S. privacy law perhaps inadequate under the analysis.
Great. So a very big court decision coming up. Nobody can predict the outcome, but perhaps there are some precedents that you might like to mention. Mike? In terms of this New York warrant case, I mean, I know that you can't comment on the case specifically, but...
Well, I can comment on the case specifically because it's being well litigated by all parties. The position that this is a unique role, the idea that this is a unique position taken by the United States is simply not the case. I think 21 of the 28 EU member states also have the reach out of their own member countries into the United States specifically to obtain computer internet-held data that resides in the United States. And so there is this extraterritorial, or there's this multi-territorial approach to what's available under domestic legislation, which is, I think, part of the Budapest Convention, authorized by the Budapest Convention, and in fact taken into account by 21 of the member states. I believe the Irish, for example, had to admit in their brief that they actually have the ability to reach outside. They just don't use it, they said, but they have the ability to reach outside of Ireland. So there's a lot going on. I think the one thing, John and I are probably not going to agree on much with respect to this lawsuit. But I think the one thing we will agree on is that whoever wins it, most of the issues that come up and are raised by this lawsuit won't be answered. That the issue that is currently being litigated, or the challenge that is being raised, is whether the statute is specifically explicit in its desire to have extraterritorial reach. And if the Second Circuit sides with Microsoft, it is very likely that that's the theory under which they would side with Microsoft. That's the one that Microsoft has argued the most, which is that the statute is not explicitly extraterritorial, so it shouldn't have this extraterritorial application. If that were to prevail, then the Congress could solve that problem by saying, okay, we want this statute to be extraterritorial. That may or may not happen. All of this is simply to say that the problems that you have when you try to impose national sovereignty on a non-sovereign space like the cloud aren't going to be solved by these simple answers. And so there is, we are going to be playing catch up as long as I live, or certainly as long as I'm employed.
Perfect. John, very quickly.
Well, just very quickly, Mike, you're Ireland says that they can take a bank, they can tell a bank that it needs to pull its bank records stored outside Ireland back to Ireland for that. And in the U.S. there's a similar principle, and countries have that, where, but we're not talking about Microsoft records here. But we've said that no, like these are the private communications of our customers. They're not ours. We don't have access to them. We don't want access to them. We want them to be as the personal papers and effects of our customers. And so that's a very different, for the Department of Justice to take the position that any data stored with a cloud provider is a business record of the cloud provider that can be turned over to governments, I think is a very unwise approach.
Isabelle, there's an enormous data center in Mons. I'm not going to name the company that it belongs to on this stage, but this must be something that you, as the Belgian DPA, are paying a lot of attention to. What do you?
Yes, of course. We are looking at the result of this litigation, of course, and I think that it will come in this month. No, it will be February to May. We are very willing to look at the decision on this field, for sure.
Perfect. Olivier, you? Great. Anybody from the floor have any questions? Oh, wow, great. Loads of hands going up. This is a lovely sight. Let's start off down here at the front. Quick reminder to you all, question doesn't mean statement, so keep it brief. Tell us who you are and where you're from.
My name is...
Oh, try again?
My name is Zoya Sheftelovich. I'm from Politico. I have a question for Michael. Why has the DOJ decided, to your knowledge, to pursue this case with Microsoft? Why not go through the Mutual Legal Assistance Treaty, which seems now, perhaps in hindsight, to have been a much quicker mechanism than this long, protracted court case has been, which I believe started in 2013?
Great. And I'm going to be a typical moderator and group the questions. I think we had another one at the back there. If we go around there, oh, sorry, making you run around and burn lots of post-Christmas calories. But yeah, we can come back on MLATs. Why not use the existing framework? And then at the back there, got a hand up. Go ahead.
Hi, thanks. My name is Camila Martera from the Center for European Reform. I have a very quick question about safe harbor. It's very secret. No one knows whether it's going to be concluded or not, but we all know that there is a deadline coming up. So I was just wondering, how robust do you think it's going to be, and how vulnerable from a new challenge before the Court of Justice is the new safe harbor going to be if the US and the EU do not address the question of the national security exemption, the question of surveillance, from a formal point of view? Thank you.
Perfect. MLATs and surveillance, a lot to think about there. So, Michael, you go first.
We're bringing the case because Microsoft is a U.S. company located in the U.S. with control over material that the U.S. needs in a U.S. law enforcement request. And if they put it in a country with which they have an MLAT, they would like us to follow the MLAT. And if they put it in a country that is not subject to it with an MLAT, and there are many, many countries like that, then what do we do? Or if they put some of it in one country and some of it in another country, then what do we do? Or if they put it in a country where they're not actually sure they can identify what country it's in, then what do we do? Or if they decide that the attachments to emails are going to be held in one country and the emails are going to be held in another, except that the old emails will be in a fourth country, then what do we do? And the answer is there has to be a logical answer, and it cannot depend upon the business model of Microsoft on how they want to put information in one country or another. And so what we're looking for is simply to say that there is a rule of law. And the rule of law is if you are a citizen of the country or a company located in our country and that you have control over information and you are required to give it under a court order, then that's what you do. That's what we believe is the import of both the Mark Rich case and the Bank of Nova Scotia case, which we've had as the law of our country, and actually the law of most of your countries since 1983. And we believe that the information that is being requested falls into that same category. Microsoft doesn't believe that. They believe that based on the distinction between content and transactional data that the statute makes, that there is a big difference and we should treat them as different kinds of items. We don't take that position, and that's basically what I think is being argued here.
Perfect. Before we come to John, Olivier, have you ever used an MLAT, and was it useful? Did you get what you wanted?
We use them, we as Europol, we don't use them, because it's the member states that ask for that information. It's their cases.
Yeah.
But they're definitely very, very useful, instrumental. And the only thing we would like to make sure is that there's more efficiency in these processes. And another thing is that my question is whether you always need to use them. I mean, the purpose of this procedure is to make sure that there's someone who takes a very careful decision on whether or not to exchange that information. That is to protect people from being just subject to an arbitrary interpretation of law by someone abroad. That protection needs to be there. But quite often we are asking for information to make sure we can protect victims. Might be even that someone is located somewhere where we're never going to reach him anyway. And it may not even be the purpose. It's just to protect victims by disrupting other forms of crime. Sometimes you need information for that. So if we're not going to prosecute anyway, why would we need to go through an MLAT? And why couldn't we just get the information for the purpose of preventing crimes, and if we at the later stage still want to go for prosecution, get that information still through an MLAT procedure, when then there is the possibility to take that decision at a later stage. But then there is no pressure anymore, because you've prevented the crimes from happening.
Interesting. So for companies, sharing is caring. John, why don't you come back on this and touch on the surveillance stuff as well?
Well, MLAT process is something that it was designed for a particular purpose, and it doesn't address the full needs. And so we very much encourage, it's a government-to-government process. In my management at Microsoft, I'm just a huge fan of doing Six Sigma exercises. Process excellence, where you get people in a room and get these little, sticky notes, and you kind of lay out a process and you ask 5 whys about, why do we do it this way? Now, I think we could take a fresh look at some MLAT things and just sort of say, well, why is it narrow? Why is it this scope? And why is the process so burdensome? I think we'd all be better off if we could figure out ways to simplify and speed up the MLAT process. I think it's also important that not just law enforcement be present for that kind of negotiation. I think I'd imagine sort of a game theory of you got law enforcement, you got civil society, and you've got others that can then talk about a reciprocal relationship of these are circumstances where we'd want information from your country, and we'd be willing to have a reciprocal relationship. And when people can, that I think can inform how the MLAT process could end up. But it's well worth doing, and I'm hoping it's also one of these things where you don't have to solve it all at once. One improvement at a time is good.
Perfect, and that's why it's like a Rubik's Cube. Isabelle, maybe you could talk to us about the surveillance question, and also, who takes all these crunchy decisions about whether it's okay to look at certain things or not? Data protection authorities. So, your thoughts on this?
Yes, I think that the Commission, as far as I know, they really want to have a new agreement that will be robust in front of justice, because they do not want to have invalidation a second time. And so national security surveillance, which of course will be taken into consideration. And in my personal point of view, I think that key issues will be proportionality. And what is interesting would be also to look at the decision that will take place in the Telespheric case, which is really looking at it's a new prejudicial question that is posed to the ECG on the proportionality of access, and is it possible to have a bulk collection while there are some specific criteria to access the information. So it's really going into details of what is acceptable, so like finding a compromise between national security and also data protection. And the other point would be also legal redress, in ensuring also access and transparency to the citizens. The idea not to be, of course, fully transparent during the procedure, but it could take place after the termination of this surveillance, because the idea is not to jeopardize the surveillance measure, but at one day there should be at least transparency and legal redress for the citizens. So that would be the
perfect, which ties in with what Brad was saying this morning about how we have democratic governments, you have the rule of law, maybe they should make decisions. Let me give the closing words to our host. It seems only fair. So, John, but we fixed it now, haven't we? The Rubik's Cube is done.
Yeah, it's a multi-year project, but we'll get there. Now, I'd like to thank everybody for being here, and Michael especially for
Big Daniel.
in the Microsoft den. Yes. No, but you're a great sport to be here, and Michael and we talk, and we talk to people in the Justice Department. We really are. We may come out with solutions in different places, but I want you to understand there really is goodwill at finding constructive solutions that work for the various stakeholders, even if we disagree on the case. But it's these set of issues are. They're really important to society, and as I mentioned at the very beginning of the conference, as technology providers, we give some thought to it, but we're not poets, we're not philosophers, we're technologists, and yet, so the group discussion, the gut values, the core sense of that doesn't My wife's a clinical psychologist, and one of the most important lessons I learned from her when she was getting her PhD was, if it feels icky, it probably is. And that as humans, we can't lose touch with that sense of, in our gut, does it feel icky? And so, don't want to end on an icky note, but technology's got incredible powers to transform our lives and improve things, and cloud computing offers just really spectacular things that we can do going forward. But we need to address the social issues along the way, and I'm hoping that some of those social ethical issues aren't going to lag 30 years behind as we move forward.
Yeah, I mean, there's always hope that having made this mistake once, we had the great look at the two different computers this morning, that perhaps we can not do it again. So let me thank my panelists. Before you go upstairs to enjoy the reception, I'd like to give the stage back to Jan Techau just to have a few closing remarks. But please do thank our panelists, and thank you for your questions.
Please, yes. time has advanced very rapidly, and you all know the old joke about complex issues. If you don't know what it is, call it a structure. If you don't know how it works, call it a process. And if you don't know what it looks like, say it has some structure. And I think, we haven't heard too many of those plastic words here today, even though it's always tempting to use plastic words when it's very, very complex. And that is to the great credit, I think, to all of our panelists and speakers and moderators. Thank you very much for a very high quality debate today. My specific thanks to John and his team here in Brussels, Cornelia, and all the rest of them who put this together, gave us their great premises here and their place to dwell in for the better part of the day. To my own team at Carnegie Europe, who tweeted the hell out of this event. And if you want to follow all of the things that you couldn't follow because your brain was already swollen, go back to our Twitter account and you can find all of the core messages of the debate there. I can only say that I've enjoyed it tremendously. We at Carnegie Europe will follow this closer. And Sinan Ulgen, who presented his paper here today, is only one of them working within the Carnegie Endowment as a whole. Thank you very much for a brilliant day, and I hope that we will see all of you, some of you, and especially our hosts again. Thanks a lot for all of this. Enjoy the rest of the day. What a way to start the week on a Monday. Wonderful. Thank you very much.